Hello and welcome to our April webinar. Today's webinar is an employment legislation update where we're looking at the key changes that happened in April, as well as a bit of crystal ball gazing to see what is coming up on the HR horizon. Thank you to all those who are joining me live, who registered for the webinar, and also those who are listening again, either through our YouTube channel or via our website. And for those who have registered, I'll be sending out a link as to how you can listen again at your leisure. The purpose of the webinars is to really give HR, business leaders and people teams some information, whether that's legal or perhaps an HR topic that maybe you've not come across before, or hearing from somebody who's bringing a different perspective to the HR space. My plan is to run them on Wednesdays, and I have cunningly called them Webinar Wednesdays. So I really do hope that you will sign up and you will join me at future webinars. And for those of you who don't know who Dore Clayton are, well, we are an employment, workplace and commercial specialist firm. We have offices in the city, in Reading, and we have just opened a new office in Bristol where we are there to service and help our clients in the South West. We support individuals, SMEs, household names and global multinationals, and we can provide advice UK, Europe and across the globe. So if you want to hear more about what we do and who we help, and more importantly how we can help you, then please do get in touch. And for those of you who don't know me, my name is Emma O'Connor. I am a partner and I also head up our client training division. So again, there are my contact details, and who doesn't love a QR code? If you hold your phone up to the screen on that QR code, that will take you to my LinkedIn page where we can become LinkedIn friends, where you can hear more about what we're doing within training, HR updates, case law updates, and invitations to webinars and training courses. And I'm really excited to introduce to you Dore Clayton training, which is relevant and commercially focused, topics and trainers who are relatable, and courses which are responsive not just to legal changes but also to our client needs, providing training for boards, HR teams, management, employee populations, whether it's legal compliance, leadership skills, employment or regulatory. Then again, please do get in touch with me to find out what training, in-person, virtual or pre-recorded, that we can provide. So we really are the one-stop shop when it comes to training. And just to give you a little flavour about what sorts of training I'm doing this month, well, it's all about sexual harassment at the moment, compliance training on sexual harassment for HR teams, people teams, boards, as well as managers. So if you want to find out more about sexual harassment training, then please do get in touch. Just a few dates for your diaries, if I may. 21st of May is our next webinar, so pop it in the diary now. Please do register to receive our updates. That one's going to be a case law update, looking at some of those legal employment cases hitting the legal and the national headlines. Also, as part of my training role, bespoke client training, yes, webinars and update sessions, but also the ability for you to come and join me for public paid for courses, with the aim then of running those courses in-house. One course which I'm really excited about and I really do find very worthwhile is the HR Masterclass. And the plan there is to run that in July and then in the autumn across our 3 offices. So if you or your colleagues are new to HR, you want to find out a little bit more about HR, you want to boost your skills and your confidence, then please do join me, looking at recruitment, managing disciplinaries and managing exits, but all from that HR perspective. So invites to follow and booking is going to be essential on that one. So what are we talking about today? Well, we're talking about those April changes, aren't we? Those changes to family leave, looking at compensation and a week's pay and why that's important. Neonatal leave as well. We're going to talk about the vento bans, and gender pay gap, GPG. Also want to look, again, a little bit of crystal ball gazing there, immigration news, what's changed and what potentially could change. And then the big one, isn't it? The Employment Rights Bill. Where are we and what's it going to mean? And I really do want these sessions to be positive. So what I want to do is to give you some tips and some techniques at the end, things that you can do now, things that maybe you need to put on your HR agenda. How can HR have that impact within the business? So we'll be looking at those as well at the end. So let's, without further ado, look at those April changes. So statutory family leave there has gone up as it does every year. Again, thinking about what does that look like, thinking about what does that mean for your individuals who are about to go off on leave, also for those individuals who are currently on leave, what do we need to change? What does that mean in terms of the lower earnings limit? Do we need to be thinking about who does and who doesn't qualify for leave? And again, we need to think about what that looks like, keeping payroll updated. So again, thinking about what we need to do and what changes we need to make with that. Also, we have the national minimum and the national living wage. And again, that's applicable from the 1st of April, or was applicable from the 1st of April. So again, we need to be thinking about what does that look like. And remember, when we think about the national living and minimum wage, it's for that wider category, isn't it? It's that wider category of worker, and not just an employee right. So again, thinking about auditing our staff, looking at the ages there, remembering that we've got those different age rates there and what's applicable, etc. So thinking about what does that look like for our workers, etc. So again, some changes to think about there. And also when we do think about the national minimum wage, of course, we have to think about the penalties potentially there for breaches of the national minimum wage, and that wonderful phrase, the naming and shaming of employers and businesses that do not follow the national minimum wage and breach their requirements there. So something to have a think about. Again, the next change that we see is obviously around compensation and a week's pay. What we tend to see now, and typically the litigation that we have within the firm, is very much looking at not just unfair dismissal, but thinking about those other claims as well. So unfair dismissal, but also discrimination, etc. So again, thinking about what those rates are and why these are important is, of course, because, you know, it's a big chunk of compensation for unfair dismissal. So we need to think about what we're doing in terms of our processes. Are they clear? Do our managers know how to conduct an investigation? Do they know how to hold a performance review meeting? So again, thinking about training, what can you do to support your managers, to give them the skills that they need to be able to run and manage these processes, to basically and essentially avoid having to pay those hefty sums and hefty compensation figures. So have a think about that and what that might look like for you and your business. The next thing I want to talk about is the vento bans. Now we say, don't we, when we talk about compensation for discrimination and whistleblowing, we say that that is without limit. And that's one of those key areas that we talk about when we talk about roles, responsibilities and risks when we're doing our equality training. And what we have, and the reason why we say that is because, unlike compensation for unfair dismissal, where we have that cap, that cut-off, we don't have that necessarily within compensation for discrimination, because it includes other things such as personal injury, aggravated damages. But what the courts have done, and again, this comes from quite an old case now, is that they've created these bans, so which are based on the injury to feelings, how damaged a person is by what's happened to them. You know, what's the impact of this on the individual. So again, the court has created some bans there, and again, these increase every year. So we need to think about the impact of discrimination compensation. We need to think about what that looks like. How can we avoid discrimination claims across the business, and what does that look like? Training, particularly when we think about sexual harassment. What are we doing about the reasonable steps? What are we doing in terms of risk assessments? That really is key, the risk assessment, to unlocking what reasonable steps you need to take, and what training we're doing to support our managers to really kind of raise the profile of these topics at work, and what does that look like in terms of compensation and risk. So the vento bans, discrimination, and obviously for whistleblowing there as well. So really important takeaway there. Next, neonatal care leave. I want to spend a little bit of time talking about that because, as we know, it's new, came in with babies born after the 6th of April. So again, something that we just need to be thoughtful about. What are we doing? What have we done? What are we yet to do? And what I want to do is kind of think about it in terms of, what are those key areas? And what some of the headlines. So neonatal leave applies to both parents. And also, just to stress again, it's that employee right. It can apply in birth, adoption or surrogacy arrangements, and it is up to 12 weeks leave that both parents are potentially entitled to, and that leave must be taken within 68 weeks of the birth or placement for adoption, whatever the circumstances there. The right is only triggered once the baby has received neonatal care for 7 consecutive days. So it's in arrears, if you like, but you've got to get to 7 days before that right kicks in. And again, it's 7 days, 7 consecutive days within the 28 days of birth or replacement. And also, just to stress though, that you get leave for an additional week after the baby has stopped receiving care. So it is a day one right. And that's important to note. So employees to take the right to take the leave is not dependent on length of service. However, statutory neonatal leave pay is, and for that, the individual will need to have 26 weeks continuous service by the qualifying week, which is essentially that 15th week sort of trigger there. And again, that's based on the normal calculation rate as well, that normal sort of statutory rate of pay that we've talked about. So let's just have a little think about some of those curveballs that we might see. Well, firstly, how is neonatal care actually defined? And it's quite wide actually, and it's not just care in a neonatal unit within a hospital. It may also include medical care, hospital care being received. It might be that it's care that a baby is receiving at home, but under the direction of a consultant. And again, it could be ongoing monitoring or visits by healthcare professionals arranged by a hospital. It can also include palliative and end of care treatment as well. So again, it's quite wide, the definition there. Multiple births. So just to stress that 12 weeks is per birth, not per baby born. However, if, for example, twins and both babies require care at the same time, and they meet that qualifying, 7 days consecutive care, then obviously you would take the leave in one go, if you like. It might be that baby 1 requires some care straight away and baby 2 requires some care, maybe the following week. Again, provided it's 7 consecutive days within 28 days, but so you might be taking your leave at different times, but essentially it is still the same, it's still 12 weeks. The leave is sort of split between tier 1 and tier 2. It's a little bit complicated. And again, it's something that, if you want some help with policies and things like that, but I just kind of want to give you an overview of what it sort of looks like. So tier 1 leave, that's the leave that an individual parent will be taking at the time the care is being given or being received. And that's probably going to be in those cases where another statutory leave hasn't kicked in yet. So tier 1 is normally taken out at the time. Tier 2 is most likely going to be taken, for example, from the mother who takes their maternity leave, and then essentially they tag on the neonatal care leave at the end of their maternity leave. So it's not interrupted. Maternity leave still stands. It's not interrupted by neonatal leave. What it is that disruption, if you like, to the maternity leave is then sort of added on to the end. It must be taken, again, subject to the employee qualifying, it must be taken within 68 weeks of birth. So what does that mean? Well, again, we need to be thinking about, don't we, what that looks like in terms of leave. So for example, you may have an individual who has taken their maternity leave and actually is in that unpaid period of leave, and then they qualify and then they take their statutory neonatal leave. So again, going from an unpaid period of leave to a paid period of leave, and what does that look like? So I think there needs to be a bit of sort of thought and again awareness around what does that look like, because potentially some of these could be out of the business for much longer than the anticipated 52 weeks. The guidance states that for tier 1 leave, businesses should be, more flexible. It's not really going to be perhaps the appropriate time for an individual to send an email saying that they qualify. It might be that you have to sort of flex, and maybe it's done over the phone. But again, you need to have some basic information, but the way that information is given, again, it might be flexed, particularly in the tier 1. Tier 2, because it's being tagged on at the end, of course, you've got that notice that can be given, so you're clear as to who, when, what, when was the baby born, etc. So think about how does that work and what your processes might look like for that. Tier 2 leave is taken in a consecutive period of time, just to sort of flag as well. So other considerations, well, of course, we might need to think about updating, not just producing a neonatal care policy, but also policies and procedures more generally, thinking about their neonatal leave, but also family leave policies more generally. And again, remembering that, individuals should not be treated less favourably because they've sought to take or have taken statutory neonatal leave. So again, that's something to think about. Also be sympathetic. This is generally quite a chaotic time where people, don't really know what's going on. It's quite uncertain. So again, be sympathetic in the way that we're communicating with individuals, and maybe just be a little bit flexible, particularly in that first 7 days before the leave potentially kind of, is available. Dependent leave, unpaid leave, holiday, those sorts of things. Keep information confidential. It may be that people may not want information scribed. So again, think about confidentiality. Keep in touch, and can we signpost individuals as the help and support? We've got an EAP, an employee assistance program. Again, so think about that. And please make sure your managers are up to date with what's going on, and they know about these rights, because what we don't want is a manager to sort of, completely dismiss it and kind of get the whole thing wrong. So again, manager training, updating managers, making sure that they're aware is going to be really, really crucial. I do want to talk a little bit about gender pay gap reporting, because I think that's one of those things that comes around every year, doesn't it? Particularly for those businesses that are caught, they've got those 250 plus employees, and we've got those different metrics that we're looking at. So gender pay gap is looking very much at pay and quartiles and different metrics. It's comparing pay in general between men and between women, and also looking at bonuses as well. And again, just looking at those individuals who were employed as at the snapshot date, and then you have a period of time to produce your report. Don't confuse gender pay gaps with equal pay, where you've got an individual comparing their pay to another individual, man comparing a woman to woman comparing their pay to a man, or vice versa. So that's very much an individual comparison. Gender pay gap is looking at the whole. Where is our gender pay gap? And the other really important thing about gender pay gap reporting is the narrative. This narrative that accompanies your reports. So again, making sure that you've got your story, where are we going on our journey here? What changes have we made? If we've made some changes, what impact is that showing, and how long do we think it's going to take before that gender pay gap is closed? Again, it's mandatory. but we've got the sort of naming and shaming. And I'm noticing a lot of businesses actually who aren't caught by the mandatory reporting are actually using gender pay gap reporting as part of their equality strategy or their pay strategy. So again, if that's something you want to talk about, find out more about, then please do get in touch. Do just want to flag as well the Equality, Race and Disability Bill. This is going to be one of those ones to watch. Government's currently consulting on it. And I think what we just need to be mindful of is obviously that this is something that is going to be introducing equal pay, again, for race and disability, as well as pay gap reporting. So it is something to watch. And again, there is consultation. So please get involved, make your views known. Immigration. We are in a bit of flux, aren't we, at the moment? Obviously, we've got new government coming in, looking at immigration more generally. What do they want to do? What's the government strategy on that? Having that balance between supporting domestic candidates, but of course allowing businesses, who operate particularly in that global space, having that global mobility to be able to recruit the best talent. So we are in flux. We expect that government white paper in May, so not long now. And again, stay in touch for updates on that. But in terms of where we are at the moment, we saw some changes, didn't we, at the beginning of the month? Fees have increased for visas and sponsorship. We've also seen some changes around, particularly in education and in healthcare care as well, and changes to sort of salaries as well. So get in touch if we can help with your business immigration queries, and I can put you in touch with our colleagues there. I do want to spend a bit of time just talking about the Employment Rights Bill. Where are we? What do we need to be thinking about? This is certainly going to be, a huge change, and it's been, stated as such by the government. So it's there. It is going through consultation. So I want to look at where we are, what we can expect to happen, and then also those key areas to watch as well, and what we can be doing now. So we're in a little pause at the moment. The bill is currently sitting in the House of Lords, waiting to go back to the committee stage before obviously the report stage. So we've seen some changes, haven't we, already from common stage, where the government have come back and clarified some sort of inconsistencies, or introduced more changes, as we saw to the time limit for being able to bring a claim for in the Employment Tribunal from 3 to 6 months. So again, that's going to be an interesting one for HR and people teams to grapple with. So bit of a hiatus at the moment, and we will wait to see where we get to with the House of Lords and what recommendations that they make. So again, we'll wait and see where we get to with that. So we are in a little bit of crystal ball gazing, but I think these are really kind of like the key areas that to watch out for, and also things that perhaps we should start thinking about now. And the key one, the big one, is obviously unfair dismissal, isn't it? And introducing that as a day one right. What we are going to see is this minimum period of employment introduced, not a probation period. We think it's looking like around 9 months. And within that time, employers will be able to dismiss staff, but they've got to have potentially fair reason, and note that there are going to be some changes to what those fair reasons potentially are. And again, if you're within that initial period and you've got one of the potential fair reasons, you're going to have that ability to have a modified dismissal procedure, whether that will be a meeting with the individual and their right to be accompanied, or whether we will see a new ACAS code. I think we will see a new ACAS code regardless. Again, we're in a little bit of flux as to what that looks like. But fair reason, fair process, we need to be thinking about that now. So what does that look like in terms of your probationary period? What do you do? Do you do anything? Training, updating, what's that all going to look like, particularly around performance management? Possibly compensation will be reduced as well if you're dismissing an individual, within that modified procedure and you do get it wrong. That initial period of employment potentially compensation will be reduced, but we don't know what that might look like at the moment. Dismissal and re-engagement, fire and rehire. I mean, basically it's going to become pretty much impossible for employers to do that, to make changes to terms and conditions of employment. It's going to become an automatic unfair dismissal. The restrictions on employers, unless they're in, severe financial straits, and even then it has to be reasonable to have either, dismissed an individual from failing to accept changes to terms and conditions, or having, employed somebody else in their place who will accept those terms. So again, it's going to become incredibly difficult for employers to be able to make those changes to terms and conditions of employment. Similarly, there's been some criticism over the proposed changes for 0 hours and low hours workers. Again, potentially there, have we got some sort of restrictions on employers being able to turn the taps on when they need that extra help? So essentially for 0 hours and low hours workers, and also for agency staff, again, this idea of creating consistency, so individuals know what they're working, when they're working, how they're working. Again, once an individual hits those sort of thresholds, they will be offered guaranteed hours. They can choose not to accept them, but that's what the proposal is going to be. And again, compensation where shifts are changed or cancelled at short notice. And again, that's going to include agency workers now as well. So looking again, how we staff, how we flex, how are we going to be able to turn those taps on and off. Collective redundancy, essentially moving from establishment to a threshold across the workforce. So again, what will that look like? And compensation for protective award, as we call it, for failure to follow those collective consultation obligations is going to increase from 90 to 180 days. So again, it's going to have teeth. Union rights, strengthening of union rights, that ability to be able to have access to your workforces, and again, an obligation on employers to tell their workforce that they do have the ability to join, a union. So again, union rights there on the increase. Family rights as well. Again, we've got those family rights, particularly around paternity leave and parental leave. A little bit of low-hanging fruit there, perhaps, but they're going to move to become day one rights, again, for employees. Some protections there against dismissal for women in maternity and when they come back, so broadening the rights there. And again, changes to harassment, third-party harassment, the so-called banter ban, as it's been called, third-party harassment for all, protected characteristics, not just sexual harassment. And again, changes to sexual harassment, all reasonable steps. Have you taken all reasonable steps and making sexual harassment, again, a whistleblowing part there. So again, risk assessments, training, really, really important. There's a way to be able to show, the risk assessment is really the key there to unlocking, where are the risks and how are we going to, what can we do? What reasonable steps can we take to avoid those claims? So as I said, I want our sessions to be practical. And yeah, there are some challenges, aren't there? And I think for the big one is obviously the Employment Rights Bill and what that means, and employers' abilities to be able to do the things that they used to be able to doing. But with all challenges comes opportunities as well. So what should we be doing? Well, Employment Rights Bill is the biggie. We are not expecting any of the major changes to come in before the autumn of 2026. So the unfair dismissal changes. But as we know, time does tick and tick very quickly. So what can we do now to prepare? Well, really, it's looking at our probation periods, getting our good practices embedded now, training for managers. What do they need to know? How do they manage performance? Not just in the broadest sense, appraisals, etc., but what are they doing during probation? Do we need to review our contracts, notice periods, business protection clauses, probation, as I've said, but also our benefits as well? And then thinking about those key policies, probation, the trilogy, disciplinary absence and performance, and again, thinking about family leave. And as I said, it's pretty much guaranteed that we will have a new ACAS code of conduct. Boosting in manager engagement. We know how important our line managers are. We train them, don't we, on our products and services, but when was the last time we trained our managers on how to onboard, how to manage probation, how to manage absence, what to do if somebody raises a complaint of sexual harassment, equality laws, all of this good stuff. So whether that's day training and manager essentials course, a stepping up to manager course, or whether it's looking at those lunch and learn, those shorter sessions, again, there are opportunities there to really boost that management confidence, give them the tools. So please get in touch with me. Happy to talk to you about training options and what does that look like and what we can offer. And again, how can you support the business? We talk about being that destination employer, don't we? So what can you do to raise that HR voice and again, support the business, creating that culture for success? And I'm just going to leave that there. Is it time to make decisions? Yeah, should we be thinking about contracts now? Should we be thinking about what our business looks like rather than waiting when perhaps things are going to become more difficult for businesses to be able to operate in the way that we're used to now? So have a little think. Is that something that we need to be doing? And again, get in touch with me if you want to talk about what that might look like. Again, I can put you in touch with colleagues within the team as well. So again, happy to get in touch. Just looking at the questions there. So there's been a number of questions there about sexual harassment and risk assessment. We may be thinking about training, but we've not done the risk assessment. What I will say, and I think it's something I'll come back separately on, is that when we think about that proactive duty, what steps are you taking? The new worker protection that we saw in October of last year, what that really is encouraging is businesses to think ahead, okay? Not waiting and sitting back for something to happen. What proactive steps can we take? And the risk assessment is absolutely key to that, because unless you know what the risks are, how can you then take those reasonable steps and demonstrate to an employment tribunal that you've taken